Hello, I'm Attorney Todd Leneve. Welcome to West Virginia Gun Law. Today I wanted to take a moment to speak with you briefly about an important Supreme Court ruling that was issued last Friday, June 28th, and its effect on the regulatory system in this country moving forward. Stick around. So today's July 3rd, 2024, and as we sit here on the eve of celebrating our nation's independence, I am happy to see this work week coming to an end. It's been a bear, and it's only been 3 days so far. But I wanted to get this video out to you, and it's going to be a quick video. There are a lot of other channels that have done very deep dives into the opinion issued in this case, and I'm not looking to do that here with you today. I want to bring you the meat of why this is important and how I believe it affects us in the Second Amendment community going forward. So the case is Loper Bright Enterprises versus Raimondo, Secretary of Commerce. This case involved a group of herring fishermen who were basically upset over various regulations that were being put in place governing the manner in which they conducted their operations. And like we've often seen in the Second Amendment community, these fishermen said, look, this is not proper. This isn't what the law says needs to happen. We shouldn't be living under this kind of regulatory pressure in doing our jobs. And so they challenged the regulations that were at issue in the case. And ultimately the Supreme Court on Friday issued a ruling agreeing that the legal standard that had been applied to agency actions for 40 years, 4 decades, has been overruled. So what we're talking about here is a concept of what's called Chevron deference. And for those of you who follow anything political, follow the courts, you may be familiar with that term. That term arises from a case involving the Chevron Corporation and the Department of Energy back in 1984. And ultimately the takeaway from that case was that the Supreme Court, as it was constituted at the time, said that administrative agency heads, unelected bureaucrats who were basically political appointees to run agencies like the Department of Energy, the Department of Commerce, the ATF, that their interpretation and application of rules when it came to issues of potentially ambiguous statutory language had to be given deference when challenged by people saying, hey, this regulation, this rule isn't fair, it's not right. The courts, in a sense, were hamstrung in just how far they could go to interpret the statute in a manner that was inconsistent with what the agency head was saying. And so the issue was that the courts had a real strict limitation on their ability to look at an agency rule and say, yeah, that's not at all what the statute said. Instead, they were forced to accept the agency's interpretation of an ambiguous statute and couldn't do anything about it. Now, the problem is that Chevron deference didn't ever square up with the standards set forth in the United States Administrative Procedures Act, which makes it very clear that any question about ambiguity of law is solely to be determined by the courts, not by an administrative agency. But under Chevron deference, we saw basically a gradually strengthening approach where the courts were saying, well, we can't do anything about this. Well, then probably in the last 8 years or so, we've begun to see courts starting to say, hey, you know what, actually that's not right. The Administrative Procedures Act empowers us as the judiciary to interpret rules, to interpret the law, especially where there's some ambiguity, and make sure that the rules that are being applied are fair and are consistent with the statutory intent. And so that really was the underlying issue at heart in the Loper Bright case. And the court basically came out of this opinion and in a 6-3 majority decisively said, from this point forward, the Chevron case is stricken. It is overruled. So what that means is that Chevron deference is dead as of last Friday. Now that does not apply retroactively to other cases that have been decided historically with the Chevron deference concept in mind. But it means that going forward, when there's a question, a potential ambiguity in a federal law, the head of an agency, again, an unelected bureaucrat who's not answerable to the people of this country because he's not subject to election, no longer has the ability to stifle our courts and say, you can't challenge me and my interpretation of this statute because Chevron deference says you have to listen to what I say. Our court said, not anymore. That concept was completely at odds with the intent of the Administrative Procedures Act, and the Supreme Court just said, hey, you know what? We're taking our authority back. So what's that mean for us going forward? Well, we look at various actions that the ATF has taken that have been really at the forefront of the news here for the 2A community recently. What constitutes a machine gun? What constitutes a firearm, in the 80% cases? Just most recently, what constitutes a seller of firearms? All these things where the ATF is saying there's ambiguity here, so trust us, we're the government, we're going to interpret it fairly and apply it against you, the people, fairly. Our Supreme Court has just said no longer going to work that way. So what we're going to see is a change in the regulatory state in this country, which really has grown and bloated to become a fourth arm of government instead of the traditional three that are authorized by the Constitution. Our Supreme Court has just said we're not going to let that happen anymore. So what we are likely to see out of this is that administrative rules are going to be more readily challenged, particularly where they involve a federal statute that might be somewhat ambiguous or vague. The courts are saying we've been empowered by the Constitution to be the body that is responsible and has the unique skill to interpret these kinds of laws and these kinds of issues with potential ambiguity or vagueness, not some unelected bureaucrat. And so when these unelected bureaucrats make decisions, like we've seen out of the ATF, that are squarely against the 2A community's interests, we're going to see the courts more empowered now to say, nope, this is our call, we see this very differently, sorry, you're wrong, and your rule is struck down. So not just with the ATF, of course, but with every other agency out there, we're going to see more decisive actions by the courts, and we're going to see more people empowered to challenge unfair rules, burdensome rules that don't seem to square up with what the intent of a federal statute was. So this is a huge case. Again, folks, I'm sorry if you were looking for deep legal analysis on this. I'm not going to give that to you today. There are plenty of channels out there that are looking at this opinion, doing a great job of explaining that if you want to get down into the weeds of what a real legal analysis is. I want to make sure you understand that going forward, we're going to see, I think, a very different landscape that empowers us to be able to go out and challenge these improper and unfair government regulations where they are not consistent with what the law says. The laws that were passed by a duly elected Congress, the members of which are answerable to we the people through votes and the importance of elections. Again, somebody like Steve Dettelbach, he doesn't care what we think because he doesn't answer to us. He only answers to the current administration, which, as we all know, seems to just love what he's doing right now. So if you have thoughts on this, comments, please drop them in the comments section below. If you have questions about specifically how the law is applied, how the court reached this decision, feel free to let me know. You can ask those in the comments section. You can send me an email through my address that's in the video description below, and I'll be happy to try to explain that to you as well as I can. But again, this is a lengthy opinion with a lot of legal analysis that, honestly, here on a Wednesday afternoon, as we're all getting ready to enjoy at least one day off, I don't think any of us are really interested in hearing. I appreciate you being here today. Thanks for spending the time. Look forward to hearing what you have to say. If you haven't subscribed to the channel yet, please consider doing so. And please consider sharing the channel with others. I'd love to try and get the subscriptions elevated so that we're seeing more people have an opportunity to see the content that we're putting out, and so we can get around the anti-2A algorithm on this platform. Hit that like button, share the video, and I appreciate you being here once again. Look forward to seeing you next time around. Happy Independence Day. Go out and do something uniquely American tomorrow. Love this country for what it is, and we will see you next time around. Until then, take care and be safe.